to or are normally based on the request of specialized police units that need, for example, the use of a car or even an aircraft, depending on the frozen goods. And also there is in the royal decree there is a specialized committee for the allocation of the proceeds of crime, and this committee is in charge also of deciding the reuse or the social use of the already confiscating goods that have been sold. Also, there is what we call a management deposit and consignment account held by the orga in order to have all the funds that are frozen and are transferred from the bank accounts to this special bank account, so-called deposit and consignment account in the orga, before any judicial decision decided to transfer it to the victims or to the issuing authorities in other countries. Of course, also at the national level, if they finally decide the court to transfer it to the what we call the treasury, the state. Well, of course, this organization has a clear international influence. I told you before, from the AROs, from the French model. We were discussing in principle, and we had a very interesting discussions on whether to follow the model that we have, in particular in the Netherlands, but also in Belgium, because in Belgium the juez de instrucción is still there, as we have in Spain. But finally, the Ministry of Justice and the government decided to have this office at the Ministry of Justice. It's a multidisciplinary office, but we think it's better to have under the control of the prosecution office, because the judicial dimension is stronger than the one that we have now. Because the first problem that we have with the orga is a very good initiative. We improve a lot. The figures are improving also, but the judicial culture in a certain way is not really identified with this model, and there is a lack of requests coming from the courts and also even from the prosecution office. Although we have a very good agreement with the orga. Initially, the first one was signed in 2016, and the renewal was in 2022. Now we start the discussions on how to draft a revision of the agreement, because we have to take into consideration the regulation on 2018, of course, but also the new directive, because regulation 2018, as I told you in a previous workshop, is still we have to revise our legislation, our mutual recognition law, due to the call for elections. The early call for elections that we have last year is still pending, and now we have to adapt the legislation to the regulation, and even more, we have to transpose the new directive. And it's something that we have to merge and prepare a new bill. And this should be also taken into account in relation to this bilateral agreement that we have with the orga. But in any case, it's very important to improve, to enhance the relationship between orga and, from our side, the prosecution office. We try to do our best. We try to in particular, one in relation to the incoming EIOs, in complex cases when we need a holistic patrimonial or financial report, we used to send these requests to the orga, They are under the coordination of the prosecution service, of course. They are entitled to draft this report. The problem is that they are very quick for the provisional report, and we receive it in a couple of weeks. But if we need a deeper one, a more thorough report, and with more information, and also completed with measures to be adopted on the spot, well, it takes too long. Olga is a very good office, but Olga is dealing with information from databases, from public registers. Not, we don't have police forces that are double checking on the spot all this information. And for a holistic patrimonial report, that is also very important. And to have those holistic and comprehensive reports, we need at least a couple of months, and that is too much when we are dealing with the execution of EIOs or even more freezing certificates. And that is a problem that we have. The delays with the information coming from Olga when the report is a deeper one. No? But if we ask just for the list of goods for natural and legal persons, in general terms, the list of properties and the information coming from the tax authorities and also from the FIU office in Spain is delivered in a couple of weeks at the latest. What are the biggest challenges that Olga is facing in the application of the regulation 2018? Well, as I told you, Olga is not a judicial authority, is not, of course, a mutual recognition judicial authority, not a issuing or executing authority, as is only an auxiliary and supporting office. And the greatest challenge is to provide these judicial authorities a quicker answer to their request. But the added value that judicial authorities are realizing that Olga might have is in relation to the management part or management subdirectorate, because management of frozen assets is really a cumbersome for the judicial authorities, and in this regard, the Olga is doing a great job. The problem is that Olga so far is not dealing with the judicial administration of companies, and this is a pending issue. And Olga is also now developing the possibility of having a valet in relation to the freezing of crypto assets. And this is also an issue, a very important issue, where there is a margin of maneuver and improvement. There are several questions. If I have time enough, I can provide you the answer that the ARO, the Olga, already sent to us, because the questionnaire, I decided not to answer it here at the prosecution office, but also with the contribution of from the Olga. And there is a question that is referred to the types and values of assets currently managed by authorities responsible for frozen and confiscated assets. And Olga answered us that Olga does not have global statistics, as they only handle cases that are voluntarily referred to the Olga by the court. And in relation to how to maintain the value of confiscating and frozen assets. Olga told us that in situations where it is reasonably assumed that the property frozen is perishable or rapidly depreciated with disproportionate costs, maintenance costs, in relation to the expected value at the time of confiscation. The Spanish legal system allows for the sale of such property before the final confiscation, the so-called interlocutory sale. But for this interlocutory sale, there is also another problem because judicial authorities, the courts, are really reluctant to do it and to sell in advance the frozen assets due to the complaints that the holders of the owners of the goods are normally filing before the courts. And in this sense, there is a recent resolution, there is a judgment that give all the they decided to compensate the owner of a luxury vehicle that was used by the police and they for the damages that the depreciation of the car. And in that is why many of the courts and judicial authorities are reluctant to authorize interlocutory sellings and also the provisional use of the frozen goods. In relation to the main challenges that competent authorities in Spain face in managing the confiscated and frozen assets,
we will
the main problem.
Sorry, Francisco, we will have another workshop about the asset management office,
Okay.
the management. So,
Okay.
yeah, thank you.
Okay, then I will go directly to the last point that I would like to discuss. You know that last week we have the EGN plenary meeting, and one of the items that we discussed was the issue of how to improve investigations during the execution phase, or the so-called sentence, conviction sentence execution phase. No? And we were discussing about the best possible solutions. One of the solutions is to extend or to clarify the possibility to use EIOs during this phase, because it's not clear whether the evidentiary purpose of the EIO is already finished, and EIOs are not the best or the most suitable legal instruments to be used, or even to promote the setting up of a new instrument for the execution phase. But when we were discussing about investigations, financial investigation, we more or less agreed that there is a possibility to investigate, to start a financial investigation just for the effective execution of confiscations, but in a very formalistic, with a very formalistic approach. Because when you need any intrusive measures, then you have a problem, because in many countries, as in Spain, the execution phase is ruled by the adversarial principle. It's not confidential. Authorizing intrusive measures is up to the investigating court, but not to the trial court. And this is something that it seems to be also a very common approach and not easy to deal with. But however, there is also a very important possibility that is underused in Spain, is the possibility to start efficient financial investigations in the so-called autonomous proceeding,
Yeah.
confiscation proceedings. That
Yeah.
is, so far we have ongoing autonomous or separate confiscation proceedings, but the financial investigation is also a very formal one, a very formalistic one, and not a deeper one, including intrusive measures. Intrusive measures that are really underused, like the monitoring of bank accounts on real time. No? To just to put you an example, no? But this is something that we have to develop and we have to explore, perhaps in the framework of these proceedings and with the assistance of the Assets Recovery Office, because it is in our law the possibility to start an investigation conducted by the prosecutors with the assistance of the police, of the judicial police, and also the organ. And this is something that we have to explore, and in relation to or linked to the new directive also and to the regulation 2018 is a very good opportunity to increase the effectiveness of financial investigations for the purpose of executing confiscation decisions, because there is a breach between the outcome of the result of the frozen or freezing at the EU level and final confiscation. It seems that 1/3 of the freezing assets are finally confiscated, and this is also a failure of the judicial system from my viewpoint. If you have any questions, I will be more than pleased to answer you. Okay? Thank you so much for your attention.
Thanks a lot, Francisco. Could you please answer to my question in 30 seconds about overlaps between judicial and police ARO in Spain? We do know that you have a judicial and a police ARO. We know everything about Spain in terms of structure, but I would like to have your point of view about the overlaps, steps about the one and the other, and how do they cooperate? But very shortly, please.
Yes, well, you know that FITCO was from the very beginning what we call the OLA, the Office for Tracing and Identification of Assets, and FITCO is still there. ORGA and FITCO are doing the same job. ORGA, they have Guardia Civil and Policía Nacional working in the office, but at the same time, FITCO is a center for, the name FITCO is National Intelligence Center Against Terrorism, and is in the Ministry of Interior, is also an OLA contact point, and is tracing assets together with the ORGA. My impression is that the coordination is not very good, and they are doing the work in a sort of silo approach. And that is something that we have to amend. And most probably, the FITCO has the possibility to trace for assets and do it also on the spot. And the formalistic or the bureaucratic approach is nowadays at the organ. I don't want to say it that clear, but perhaps Olga will have another opinion, but that is my impression. And the thing is that sometimes are under supervision of judicial authorities, but sometimes we don't really know what is the scope of the financial investigation they are developing. Because sometimes they act upon a request of another organ, of another ARO, of a carrying network, but not under the supervision of the Spanish judicial authorities. And if we are there, we will have the possibility to improve the coordination between them, or to assign or allocate one request to one particular tracer, asset tracer, police asset tracer.
Thanks. This is what we expected from you. Thanks a lot. Let us proceed with the next speaker. Do we have any question to Francisco? Hope not, because we are running and Bulgaria is not here, or is here? No? 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 Non c'è Bulgaria.
There should not be. There's no. There's the prosecutor that intervened.
No, no. Okay.
Okay.
Okay, good. Romania, Bulgaria, Ukraine.
So there's not France, Lithuania, Poland again, but I suppose not. We can definitely go to Ukraine. Thank you very much for your intervention.
Prepared?
You're welcome.
Okay, good. Ukraine is there.
Yeah, hello, colleagues. Do you hear me?
Yes.
Yes.
Not really very well, but it's okay.
So I'll do my best for you to hear me as good as possible. So,
Okay.
dear participants, dear members of Recover Project, my name is Vladislav Zhornitsky, and I'm the head of the
Non si sente
National
niente.
of the National Asset Recovery and Management Agency. And I'm honored to participate for the first time the event you organized. And I'm honored
Sorry
to
if I
present-
interrupt you. The audio is not really the best, as you can see. Can you put close to your mouth the microphone? Let us see.
I think that it's the headphones
Do you have a microphone?
Maybe I'll take some time to solve this problem with the micro, okay? And
If you have
give my
another
chance
microphone.
to another participant.
I think you are using the microphone of the computer,
Yeah.
but you have a
headphones.
sorry, just for listening.
Yeah, I'll try to handle with this problem.
The quality of the sound is
Yeah,
audible.
he's proposing to change to the next one in order him to settle all the things, and then we can go back to him if I've correctly
Yeah.
understood.
But we have another one.
Yeah, so
You're right, yeah,
maybe we
you're
can go
right.
to Moldova and then come back to Ukraine.
Okay, good.
briefly. So
We change you with Moldova and see if Moldova is a better microphone.
Yeah, good afternoon.
Much
Do you hear
better.
me?
Yeah,
yes,
Much-
thanks.
very well.
Okay. Okay. Let me introduce myself. My name is Vitaly Raku. I'm the head of Financial Investigation Directorate within Criminal Asset Recovery Agency. Actually, I represent Criminal Asset Recovery Agency of Moldova. So let me share with you my screen for my presentation. Yeah. Sorry. Oh. So can you see it?
No, probably it's arriving.
Sorry.
No,
Can you
we
see my
can't.
presentation?
No.
No.
No. Let me try. Can oh. Now?
No.
Can you see?
No, I'm sorry. If you want, we can. You can share it to me or send it to me. I'm sorry. Or I don't know because
Let me try again to share it with you.
Okay, now we see it. Thanks.
Yeah. Okay.
Not in full
Okay.
screen, but we see it.
Going full
Yeah.
screen.
Now. Oh, perfect. Perfect.
Click.
So yeah.
Questo non è full screen.
Faccio io.
Thank you.
No, deve andare sotto e cliccare sul, eccolo lì, quello grigio deve cliccare.
Yeah.
Do you see it? Yep.
You need to click on the button down and put on full screen. You know how to do?
Let me try.
Okay, disaster.
Right side. Under
Yeah.
off.
No, you went out.
Again.
Okay,
Yeah.
try again. Okay, leave as it is, better than destroying everything. Okay, go ahead. Tu cerchi di... La correzione amica Patti. Grazie.
No. Oh. So, did you see my presentation or not?
Yes.
So, shall I continue?
You can continue, yes.
Yeah. Okay. Thank you very much for the invitation to the workshop. So, and the opportunity to share the Moldova's experience in asset recovery field, and our recent improvements in asset recovery. So, first of all, asset recovery is a priority for Moldova in its efforts to tackle criminality, especially organized crime and corruption. And Moldova, I would like to start first of all with national legal framework. We are continually enhancing our legal framework in recovery proceeds of crime. In recent years, we have made significant achievement in this area in order to transpose EU standards, international standards in our legislation. For example, in the past, until 2017, asset tracing, asset seizure were more an exception rather than rule for criminal investigative bodies. In 2017, we adopted two crucial laws related to criminal to asset recovery in asset recovery field. The law 49, by which criminal procedure was completed with the chapter criminal asset recovery. Due to these amendments to the criminal code, the asset recovery was incorporated into the criminal procedure code as a mandatory process to ensure that law enforcement agencies and prosecutors who investigated the crime are accountable and give the equal priority to both prosecution process and the process of recovery proceeds of crime. New legal provision related to asset recovery refers to the parallel financial investigations. They defined this, what means the parallel financial investigations, establish the cases when this investigation can be carried out. Also, the authorities who is empowered to perform these investigations. Also, the procedure of managing and interlocutory sale of seized assets were regulated as well. Secondly, the second law, law 48.
Sorry to interrupt you, but I remember that your presentation is only on the cover page, so you are not going on.
Oh.
You need to advance the presentation, otherwise.
You can see how I'm changing my slides or not?
No, your slide is the first page. You need to go over. Okay, now we have.
Okay, then okay. I'm not sure in full. Now you can see it.
Yes.
Yeah. Okay, the second slide, yeah?
Yeah.
Yeah,
Yes.
okay. Okay. So by law 48 we set up a criminal asset recovery agency. Um, this agency is a law enforcement agency which support um other agency which investigate crimes, the prosecutors as well. We're working tight with the anti-corruption prosecutors office and with prosecutors for combating organized crime and special cases. Uh, another later were adopted by the government other documents, important documents, legal framework. One is related to evaluation, management, and disposal of criminal or seized assets, which refers to the provisions related to how to manage seized assets efficient. I mean, and also how provision related to sale seized assets in order to preserve the value of these assets. Another documents is technical concept and regulation of system, our database register called Register of Seized Criminal Assets. Now we are in the final stage of developing this database for keeping records of seized and confiscated assets. For us, it's important document. Without clear statistics, is challenging to allocate necessary resources for managing and maintaining these assets. For example, storage space, supervisory personnel, maintenance. Funds must be planned based on the number, on the type of assets. So it's important to have this database in place. Nowadays, only the General Prosecutor's Office provides this data, but these data are inaccurate because they gather this evidence, this data from the all prosecutor office and the all criminal, all the investigation body who apply seizures, and this data is very inaccurate, so it's very hard to understand the total value of the seized assets, which assets were seized, and yeah, this is related as well to the confiscated assets. By implementing this register, we hope that we'll make an order related to the seized and confiscated assets. Another important piece of legislation is National Asset Recovery Program, adopted at the end of year 2022. Actually, this program represents a comprehensive strategy on asset recovery designed to be implemented over the years 2023-2027. This program includes an action plan serving as a roadmap for the authorities to strengthen legal frameworks, enhance institutional capacities, improve coordination between agencies, increase public awareness and engagement in asset recovery. So nowadays, the biggest challenge is to draft the law on civil confiscation and to pass this law to the parliament and to adopt this law. Recently, this draft of civil confiscation law was expertise by Council of Europe experts. So now we have to make this to make some improvements to our draft law and to pass it to the parliament. Another important innovation in asset recovery field is establishing a task force communication platform.
Sorry to repeat you. You need to advance the slides, otherwise we don't understand anything.
Yeah.
So
I'm
if you advance,
yeah, I will advance.
It's your turn. We cannot do from us.
Yeah, I
Okay.
agree with you. Yeah, I'm
Okay,
talking
good.
now about the. Yeah,
Okay.
I understand perfectly. So yeah,
Sorry.
in 2023, yeah, we established a task force communication platform, cooperating to facilitate cooperation between authorities involved in asset recovery field. It's in this platform are entities like Ministry of Justice, National Anti-Corruption Center, Ministry of Interior, Ministry of Finance, Tax Service, Customs, and General Prosecutor Office. The main objective of this platform is to discuss challenges faced by authorities during the asset recovery process and to propose effective solutions to overcome this challenging. So I'm going back to the criminal asset recovery duties, criminal asset recovery agency duties. First of all, the main duty is conducting parallel financial investigation, seizing and freezing criminal assets, as well as another duty is asset evaluation, management, and disposal of seized assets. Also, we keep records of seizing assets. We're participating in the repatriation of confiscating assets, in negotiation of related to the repatriation of confiscated assets abroad, and last but not least, international cooperation and exchange of information within competent foreign authorities as well. As I mentioned, we are a part of National Anti-Corruption Center. We have both competence of asset recovery offices and asset management offices. We're a small country, so we don't need to have a separate asset management office. All these competence are in the Criminal Asset Recovery Agency. We have five departments. I'll talk briefly about each of these departments. In our staff, we have 35 people. So first is the Financial Investigation Department, who is responsible to carrying out parallel financial investigation, gather evidence regarding assets, as well as they where freezes and seizes identify assets. When we talking about parallel financial investigations, it's crucial to highlight that the success of efficient asset recovery depends on how well we identify and trace the assets at the early stage of criminal investigations. It's important for us that to receive a request from the prosecutors, from the criminal investigative bodies who perform criminal investigation, to receive the request to perform this parallel investigation at the beginning of the criminal investigations. So for each agency who is responsible for tracing assets, is also is important to have effective tools to carry out these investigations. So in our team, we have criminal investigators, we have intelligence officer who performs special investigative measures like surveillance, wiretapping as well. OSINT investigations is important as well. This investigation is it's extremely important that when we talking about to identify to trace the assets which were transferred to the third parties. For us, it's challenging when we have to identify the assets registered on the other persons, and to gather evidence to prove that the true owner is our target, true owner or beneficial owner of a specific assets as our target. We have IT and analytical department. We have access to over 30 national databases and private databases as well. Here I'm talking about population register, real estate register, legal entities register, transport register, tax service databases, customs service databases, police border as well databases. In our staff, we have analysts who performs financial analysis as well. Our another unit is international cooperation section, which perform international cooperation with foreign counterparts. And the last department within the criminal asset recovery agency is evaluation, administration, and disposal department. Its task consists in evaluation of identify assets. It contributes to procedure planning before to plan a future seizure of assets, because we don't want to seize the assets which the cost of maintenance is very high, and we don't want to our expense to be bigger than the value of asset itself. So our competence to perform parallel financial
I
investigations.
want to say to you that you are on the fourth slides of 17. So please, yes, your time has expired 20 minutes over. Could you please summarize the rest of the slides in 5 minutes? Because otherwise we stay all the afternoon following your presentation.
Okay. I'm trying to be
thanks a lot.
good.
Okay, yes, thanks a lot.
Yeah. So we are performing financial investigations in 55 income generation offenses, such as corruption, money laundering, illegal funding of political parties, embezzlement, fraud, trafficking in human beings, tax evasion, smuggling, digital fraud as well. Some statistics: we are perform parallel financial investigations in over 1,000 requests from different authorities, prosecutors, Ministry of Interior, Tax Service, Customs, and we investigated over 2,000 suspects in criminal cases. Interinstitutional cooperation as well is very important. We cooperate with prosecutor offices, with our FIU, local FIU, with National Integrity Authority, Tax Service, financial institutions, for example, with banks, where we can exchange information with banks without a court order. We can obtain this information upon their request, and we set up an encrypted secure channel in exchange with banks to exchange information between us. International cooperation, we are part of CARIN network. As well, we are connected to direct connection to Siena channel at the Europol. We are the member of BAMIN network, and also we cooperate with International Anti-Corruption Coordination Center in our exchange of information with other authorities from abroad. Some statistics: were in 2023. We sent 147 requests to different countries, most of them to Romania, France, Spain, Italy, Switzerland, UK, Turkey, Belgium, and we received 31 requests from another country to provide additional information, and here we received from Ukraine, from Spain, France, Latvia, Ireland, Poland, Switzerland, Germany. If we talk about seizure, we have two tools actually to secure an asset. We're talking about seizure and freezing. Seizure is for the purpose of seizure is for reparation damages, to guarantee enforcement of a fine, to secure potential special confiscation and extended confiscation. Our criminal investigative officers within criminal asset recovery agency have the competence to apply this seizure, as well as we have the tool of freezing of assets. We can the head of criminal asset recovery agency can issue a freezing order for 3 working days. Also, we can freeze an asset on a written request from the competent foreign authorities. If someone, if for example, an asset recovery office from another country request to freeze an asset in Moldova, we can do it regarding by our law. Statistics related to seizure. During the period of 2018 up till now, we seized assets with approximate value. I converted it in euros to be more understandable. The total value of the assets are over 432 million euros. We seized different types of. This is between
about 1 year.
Yeah. This is between 2018 till 2023, the end of 2023. Yeah. Did you understood?
Yes, we understood.
Yeah.
Okay.
Yeah.
Now.
Yeah. Okay.
I have
Yeah.
3.
Yeah. We see different types of assets. Most of them are real estate. The half of them are real estate. We see the cars, aircrafts, cash. We deposit our cash in a treasury, bank accounts managing by the agency, as well as we have the experience of seizing cryptocurrencies as well.
Sorry, but you can seize. Do you have the power to seize?
Yeah.
Only for 3 days?
No. As I mentioned, we have 2 types of securing an assets. First one is freezing. We can freeze an asset for 30 working days. The head of agency can issue an order of freezing an asset, and the second one is seizing. And the seizing is we can issue we call it ordinance, and this ordinance is issued by the criminal investigative officer. And after that,
it is a criminal investigative officer, is a law enforcement institution, or is a judicial also?
No, it's a part of team of criminal asset recovery agency.
Is a law enforcement? No.
Yes.
Yeah, without judicial authority, without prosecutor.
No. After that, we send this ordinance to the judge to confirm, to authorize the seizure.
Yeah, but in any case, you have this power.
Yeah.
So, okay, so you don't need to change the. You are more advanced in relation to the.
Actually,
also more power.
As if we look at the new EU directive, I think we implemented it at 80%, I would say, more or less, related to this freezing power, to financial investigations, and so on and so forth. So, related to
which are the problems that you find in your activities until now?
Excuse me?
Which are the problems that you ever found in your investigation, in your activities, not for the asset management, but for the investigation?
Yeah, the most biggest problem, I think, is to gather evidence to prove that, for example, specific assets registered on third parties is belonged to our target, and to convince the judge that the real owner or the beneficial owner is the specific person. Is the first what we still which but I think this challenge is for everyone. The second one is international cooperation. For example, we have the access for the lots of databases, but when we request from another country, for example, the taxes information from tax service, customs, or maybe the border crossing of our targets, we didn't receive information related to this data because our colleagues from abroad, they don't have the access to these databases. So it's important to give the access to these databases to all the asset recovery offices in order to share this information informally with between agencies. So this is very important for us in order then to identify brief assets abroad. Because if you look more in our statistics, a fourth part of seized assets are abroad, and more our citizens who commit crimes, they transfer their assets to abroad and to invest in these illicit gains not in the country but in other countries. So this statistics related to where the countries where we seized assets, the total amount is over 100 million euros. The most valuable assets are in Spain, in Switzerland, in France. We seized hotels, some mansions, for example, in Alps or in Geneva. So it's related to and my ending part of my presentations is it's new amendments to the criminal procedure code related to enforcement confiscation decision sent in the Republic of Moldova to be enforcement. So the responsible authority, it will be Ministry of Justice. They can apply, they can request before the confiscation order would be enforced by our judge to request to apply seizure of specific assets if these assets are identified, and the fiscal state service is responsible for selling the assets in order to, for example, if the assets was confiscated in Moldova, fiscal service that would sell these assets.
So the Ministry of Justice has the power to influence, to ask for precautionary measures. Is there not the separation with the powers?
No, I'm talking when it comes to enforcement, the confiscation decision sent by other states to Moldova.
Okay.
Yeah. And related to asset sharing, also Ministry of Justice and Ministry of Finance is responsible for negotiating this sharing of assets, and the asset recovery agency would be the authorities who would help them and participate in the negotiations.
Attenzione, ti il microfono.
Yeah. And at the end of my presentation, the asset sharing is returned to the requested state based on negotiation agreement in accordance with provisions of international treaties. And in absence of this agreement, the assets which value is less than 10,000 euros it goes to Republic of Moldova, and which is more, it goes 50-50 would be share this assets with requesting state. So yeah, and also from this sum will be deducted all the expenses related to asset tracing, asset management, asset related to sell these assets, and so on and so forth. So thank you for thank you for your attention, and let me know if you have any questions. And
thank you very much indeed for also the information you have provided. Any question to our colleague?
I would have some aspects, but I don't know if they are a little bit away from our main interest. But they regard the, asset freezes related to Russian sanctions, your position related to Russia, and in general, your position related to Transnistria, which is maybe a region of the state. I don't know how much you control, and you are right to impose strict rules on that region, but just a very, very brief overview on asset freezes and Russia and Western sanctions is maybe relevant for many profiles.
Actually, yeah, Asset Recovery Office, Moldova Asset Recovery Office is not dealing with sanctions. It is not in our competence to freeze assets, sanctioned assets related to Russia. There is another entities responsible for that, is our security service, as well as our FIU as well is responsible. So we are not, as asset recovery agency, we are not responsible to enforce some decisions related to sanctions to Russia. And as well, as you know, we don't control this territory of Transnistria, so as well, we don't have any power on this territory. We cannot seize any assets there, so and we don't have any cooperation with the authorities there. So yeah.
Sorry, I have another question. Because you are the power to apply freezing order, sales and so on. So, but this is a question also for the other asset recovery representatives of asset recovery office. The role of the asset recovery office is to identify the assets to seize, to confiscate, and so on, or also to find the evidence of the legal origin. Because in order to freeze, you must have some evidence, some elements about the legal origin.
Yeah, we have the criminal investigative officers, and this criminal investigative officer, he's responsible for gathering evidence as well. He or she can make searches in order to find this evidence. Can request this information from different entities, legal entities, can interview people as well to obtain relevant evidence. So we have full, let's say, competence to gather evidence as it provides in criminal procedure code, but we are not doing a criminal investigation itself. We don't gather evidence to charge people for an offense. We just gather evidence related to the assets with the proceeds of crime, or maybe to identify assets, for example.
But also to the legal origin, no?
Yeah, as well. Yes. We help, for example, prosecutors to identify the illegal origin of the funds.
Yeah. Not only, for example, one evidence can be the disproportionate value in relation to the legal incomes. Yeah. It is easy also for asset recovery office, no? Because you can confrontate, no, the legal and the assets. But in order to find other evidence about the legal origin, you have to investigate in some way. Not only
just
the bank account.
to answer to your first what you mentioned about this disproportionate difference between legal income and the assets. Actually, we provide this expertise to the prosecutors. We have experts in our office which can provide this expertise to establish this disproportion.
Okay, so you have also some expert in order not only to identify but also to establish the legal or illegal origin of these assets. Okay. Okay, thank you. This is a question also if other representative, for example, Nabi of Romania, would like to answer to this question. Which are your power only to identify or also to give some evidence of the legal origin? Because this is important in my opinion, in order to establish the role of a state recovery office.
Yeah, we do it.
Nabi?
I think we can proceed with the next and the last speaker, as I understand. Our Ukrainian friend who has found a new microphone, I hope. But you have found a new microphone, but you don't hear us, or at least we don't.
Yeah, now I can hear you, and sorry for the trouble.
It's worse than the other.
It's worse?
It's worse than the other one. It's better that you take the first one.
Really?
Yeah.
Oh.
Okay, but we will try to understand something.
So do you hear me now or no?
What can I say? It's 4:10 in the afternoon. We are satisfied with something. It could be short, please.
I'll try to speak louder a little bit, and maybe you'll hear me.
Okay.
Yes, yes.
Oh no.
We are able to understand. Yes. Okay.
Is it better?
Go ahead. Frankly, go ahead with your presentation. No problem.
Okay, I'll try to share my presentation with you. Can you see it?
Yes.
Yeah. So I'm extremely sorry with the problems with our micro. Because of Russia's attack on our energy infrastructure, we have power outages, and it was even a big challenge for us to connect online for today's meeting. But I still hope you hear me and you can see my presentation. So, dear participants, members of Recover Project, my name is Vladislav Zhornitsky. I'm the head of the International Department of the National Asset Recovery and Management Agency of Ukraine. So I'm honored to participate for the first time at the event you organized, and I'm honored to present our organization to distinguished participants. I would like to present you information about the work and the achievements of National Agency of Ukraine for Fighting, Tracing and Management of Assets derived from corruption and other crimes. The short name is ARMA. And just a few words about our agency. Since we are a candidate country for EU membership and our legislation should be harmonized with all EU acts named today. We are now on the way of implementing the relevant directives and regulations in this area of asset freezing, confiscation, and asset recovery. And this is our big homework and great responsibility, not only for ARMA, but for the whole country. And as a special governmental body authorized to formulate and implement the state policy in the sphere of tracing, finding, and of assets that are subject to seizure and that are aimed to be seized, as well as management of seized assets in criminal proceedings, ARMA is the only public authority of Ukraine modeled on a similar institutions as in EU member states, and at the same time it stands as fully independent operational institution and has no analogs in the Ukrainian system of public authorities. So a little bit more about ARMA's functions. So ARMA is responsible for finding activity aimed at establishing of the fact of existence and tracing the activities aimed at determination the location of assets, property that are subject to seizure in criminal proceedings. We are entitled to support criminal investigation cases by means of taking measures on tracing and finding of assets upon request of the investigators, detectives, pretrial investigation authorities, prosecutor's office, courts, and for the purpose of seizure and confiscation of such assets. Ensuring pre-MLA international cooperation with relevant authorities of foreign states, international organization dealing in the sphere by taking measures on tracing and finding of assets, as well as requesting them on asset finding and tracing activities. Taking part in the representation of state of Ukraine in foreign jurisdictional bodies in cases related to return of assets derived from corruption and other crimes. Also, the asset management area includes such functions that ARMA executes court decisions. We are entitled for management of assets seized or confiscated in criminal proceedings in order to preserve or maintain economic value of the assets by transferring into management using asset management agreement or disposal, sale with further cash disposal in state banking system, temporary till the end of the criminal proceedings. Some words about our achievements. So the 2023 was a record year for the number of assets tracing requests received by ARMA. The numbers reach almost 13,000 requests, which is almost 40% higher than previous year. There were almost 800 of such requests. And this demonstrates the growing efficiency and credibility of ARMA and national and international levels. Also, it's not included in my presentation, but I wanted to mention then that in annual report of for 2023 in annual Karin's report, Ukraine was noted as one of the most active participants in international cooperation. In their report, experts mentioned 436 requests from ARMA, and it shows the importance of asset recovery during the wartime. So, as you know, this is the period of full-scale invasion. In addition, in 2023, Switzerland, United States, Ukraine, and the United Kingdom received the largest number of requests from Korean members for asset identification and tracing. So it also shows that ARMA demonstrates the high level of trust of international partners to our agency. And the number of such requests to Ukraine, to ARMA, is 138. So let's move to another slide. So in order to identify and trace the assets of war criminals and collaborators, ARMA specialists carry out active search operations for the assets of sanctioned persons, defendants or in criminal proceedings in response to requests from Ukrainian law enforcement agencies and the Ministry of Justice, and are also members of working groups in international projects. In general, since the beginning of full-scale invasion in 2022, ARMA specialists have found a large number of assets of sanctioned persons and persons involved in criminal proceedings abroad that are directly or indirectly related to the invasion of the Russian Federation. Most of these assets are luxury real estate, expensive yachts, and luxury cars. So, in particular, some examples, some land plots in London, mentions also in London, famous ski resorts in Montenegro, real estate in the center of Paris, and chalet near the Versailles Palace, and so on. Very, as you can see, very expensive and high-valued assets.
I'm sorry to interrupt, but what does it mean that you have found them abroad? Meaning that you have initiated a proceeding that has carried out to discover the fact that those goods belong to sanctioned entities, or what was the role of ARMA in these findings, finding those assets?
So it was made by the request of our law enforcement agencies, such as Security Service of Ukraine, the Prosecutor's Office, and through the Korean network, Interpol networks, we managed to find those assets abroad. So some words about our legislation. Despite of the things I named, ARMA is a key element of Ukraine's anti-corruption architecture. As one of the tasks is also recovering of assets derived from corruption. I would like to know that in line with our anti-corruption and asset recovery efforts, the government of Ukraine has adopted the asset recovery strategy for 2023-2025. It was developed by ARMA, and which aims to improve the process of recovering assets derived from crime, including corruption and money laundering. The strategy aims to adoption of amendments to legislation to improve the efficiency of asset recovery procedures, ensuring the professional development of employees of the agencies involved in asset recovery and management, strengthening cooperation with international organizations and foreign governments for effective asset tracing and recovery, implementation of mechanism to ensure transparency of the asset recovery process and their further use for the benefit of society. This strategy is an important step in strengthening Ukraine's anti-corruption system and ensuring justice is done through the recovery of assets illegally transferred from the country to another jurisdiction. I would like also to demonstrate and to show you some key aspects of ARMA's international cooperation in the field of asset recovery. based on specific results of specific examples and current legislation. So the first case in history of Ukraine in our practice is the yacht Royal Romance owned by oligarch Viktor Medvedchuk and owned by his family, and it is located in Croatia. So this asset was transferred to Arma for further sale. So briefly tell you a little bit of history. So in March 2022, the Ukrainian District Court, Lviv District Court, seized his property, Viktor Medvedchuk's property, and not only yacht, but including this yacht. The Prosecutor General's office requested competent authorities through MLA request the competent authorities of Croatia to recognize the decision of Ukrainian court. And on May 2022, the District Court of Split, Republic of Croatia, ruled that the criminal case against Viktor Medvedchuk was valid and the yacht should be transferred to Arma for further sale. This decision was upheld on appeal. Since receiving those court decisions, Arma has worked to amend Ukraine regulatory acts, Ukrainian legislation, because we had no any options provided by our legislations to sell this property abroad. And in November 2023, the government adopted historical, for us, the historical procedure amendments to resolutions, creating the equal, clear, transparent conditions for participation of organizations from all over the world with necessary experience in organizing the competitive bidding at the international level in accordance with the best international practices and principles of auctions. So we can involve the world auction houses to sell this asset. And for the first time, so this is the first case of civil forfeiture in the history of Ukraine, and because this asset is located in especially because this asset is located in foreign jurisdiction. It's worth noting that the decisions of Ukrainian and I think also the of Croatian courts and recognition of those decisions abroad, they were guided by recommendation of Group of 8, G8, within the framework of subgroup of criminal justice approved by G8 best practices for administration of seized assets. As noted in relevant recommendations, they are aimed in particular at supporting states in preserving the value of seized assets. At the same time, one of the key recommendations in that is that in court proceedings in accordance with national legislation, the sale of assets should be allowed before the final court decision in case and in case of confiscation and recovery of assets. In respects of those assets that rapidly depreciating in value, such as ships, aircrafts, cars, animals, farms, and etc. And the state should ensure the consideration is given to authorizing the sale before and final court decision is made in case of assets that are too burdensome to manage. Intent the proceeds of the sale should be retained in accordance with national law until a final court decision is made and the assets are confiscated or recovered for the benefit of the state. So ARMA is currently taking measures to enforce those court decisions, and I would like to note and mention some problems also in legislations that we have for now, that according to the Ukrainian law, ARMA is not authorized to independently request mutual legal assistance.
We are looking only to yacht. Your slide is stopped. Looking to ships.
Yeah, I'm talking about the same case, because all these problems appeared were detected by ARMA and our specialists in this case, in this first international case of asset which is located abroad. So the problem that the ARMA is not authorized to independently send MLA requests, and such requests are made by Prosecutor's General Office during pretrial investigation, and Ministry of Justice make such requests in criminal proceedings in criminal proceedings during the court proceedings. But now we understand. But now, as for now, we understand the mechanism of asset recovery in a particular case, and we realize that it would be much more productive and effective if ARMA should be entitled to request international legal assistance directly. So amendments to procedural courts code of Ukrainian already initiated by ARMA, and we hope our government will adopt them. This case, I think for us, it could be it can be considered as example of effective mechanism of cooperation between Ukrainian law enforcement agencies, ARMA, and foreign jurisdictions in field of recognition of Ukrainian court decisions in the field of asset recovery abroad. So another case I wanted to mention is the aircraft. So in according with the rulings of Ukrainian court in March 2022 and in November 2022, the Russian the aircrafts owned by Russian company Volga Dnieper Airlines Limited Liability Company were transferred to ARMA's management. ARMA found detected one aircraft which is still located in airport Toronto International Airport in Canada, and 3 aircraft in Leipzig International Airport, it's Germany. And the location of others aircrafts, unfortunately, is unknown by now. I wanted to mention here that Canada has become the first G8 country to introduce a legal regime for seizure of confiscation and transfer of assets for Ukraine's needs. This applies to assets owned by foreign states, individual and legal entities sanctioned by Canada in response to Russia's military aggression against Ukraine. Namely, it's Bill C-19, Amendments to the Special Economic Measures Act, SEMA law. It provides the possibility of seizing the and restricting the assets of sanctioned individuals, establishes a legal regime allowing the confiscation of seized assets, allows Canadian government to sell confiscated property and use the proceeds for specific purposes to aid a foreign state. In our case, it's Ukraine, and facilitate information exchange between relevant authorities regarding potential assets for seizure and confiscation. But still, the procedure under the SEMA may take up to 2 years, considering the preparing documentation for court hearings, it takes more than 8 months. However, implementing the mechanism through enforcement of Ukrainian court decision and its legislation and its legalization in Canada, as it was made with yacht in Croatia, it could complete the process within the 6 months. So now we are in tight communication with our Canadian partners to find the way of resolving this problem, this mechanism, to transfer them in criminal proceedings through legalization it in Canada, or through the special economic measures acts of Canada. So as for now, it's two of the most famous and most valuable Ukrainian cases of finding assets abroad and recovering them to Ukraine. So thank you, dear colleagues. Sorry one more time for poor micro, but I hope next time I'll do my best to change this situation.
Okay. Thanks a lot. We have concluded the presentations. Any question to the Ukrainian presenter and Moldovan? Too tired? Okay. Let us go.
Maybe, sorry, Ernesto, I would like to ask to the public prosecutor in the end of our workshop if in their experience the Asset Recovery Office is a real useful instrument to identify the assets or to gather evidence of the illegal origin, or is another body, but not so public body, but not so, in the end, not so useful. It is a kind of provocation, but I would like in the end to understand if in the concrete praxis of your countries this is a question for the prosecutor, also for Anita or Francisco, Joao.
Yes, if I may, well, taking into account from where we come, I think it's another value, of course, but it's very useful for tracing. But in order to gather evidence, well, we have to really improve the legal framework. I think the transposition of the new directive is going to be a very good opportunity. But the main problem that we have is that the Asset Recovery Office in Spain is under the structure of the Ministry of Justice, and then it would be much better to have it in the structure of the prosecution service for this purpose, in order to have this comprehensive and holistic approach.
Yes, in order to cooperate in a best way. Yeah.
Yes.
Okay, in the direct best way.
The relationship that we have is very good. I have to be also frankly speaking and to be honest. Yeah.
If I may say something from my part, I would say that it is very important. Traditionally, when we look into a crime, we only took we only gave importance to the evidence needed to prove the crime. Now we have to look to the financial aspect, and financial aspect sometimes also necessary to prove the crime. So I think that aspect is something that we have to develop in the future, because of course financial investigation also can give a very important can be a very important tool to fight the crime, not only to recover the assets but also to prove the crime.
Yes, to get
sometimes
the evidence of the legal origin. Yeah.
And if I may, and sometimes the ARO is inextricably linked. You
Of
cannot.
course,
Yes.
of course, of
Yeah,
course,
yeah.
of course, of course.
Yeah.
The
For
problem is
instance,
that
money laundering.
first of
Money
all-
laundering. When we are investigating money laundering, we are already doing a financial investigation. Of course.
Yeah.
Yeah, you have to identify the assets, but also to get evidence of the legal origin. Yes. Okay.
I think we can go toward very short conclusions, no more than 4 or 5 minutes. Let me say to you what we have learned today from the morning until the afternoon. The two main questions were, what are the procedural steps of the ARO activities, either on judicial or on police? And the second question was, do they cooperate each other? Which is the level of international cooperation among the ARO? We understood in the beginning that the European Commission is aware of the very low level of numbers of seizure and confiscation around Europe, and for this reason, they are trying to solicit reforms on the ARO systems. The same recent directive is pushing to change something in this direction. We are effectively aware that theoretically judicial is dealing with the eligibility of the request and police with the tracing of the assets. These two things should be working together, but in a separate world as we are of the bureaucracies, they don't work together, with the exceptions of those. I've been listening to Estonia, for example, and they work together. Spain, there could be some forms of cooperation. Italy, I don't know, but in a way or in the other, the forms of cooperation are very low. The main reasons which have been said today to us is language, fragmented legislations, and low level of recognition of the tool. I'm speaking about the regulation 2018-185 that people and some prosecutors don't know. Probably they belong to the old generation of prosecutors and they are not willing to know more about. And this could be an explanation about juridical culture of the prosecutors, having in the end a very powerful instruments, but they don't implement these instruments. This could be one of the reasons of the short numbers we have in front. Having said that, the problem we do have how to change the system, because the system is totally inefficient and with a waste of resources, considering that we have 2 AROs, and sometimes they don't collect data also about what they do. Also, if in a way or in the other, the results are very poor. If you compare with national activities and the ARO look working very well, which means when they know the system internally, they work. When they don't know the system about international cooperation, they don't work. This is practically the conclusion of this workshop. And there should be a lot of different ways for reforming the system. The directive recently of April 2024 is soliciting to reform the systems. We will see how it happens. For the time being, these are my conclusions. I don't know if Anna Maria wants to add some other conclusions. We want to thank you all for participating to this workshop. For providing us with data. Please send data when you have, and your impressions also are absolutely crucial for us for understanding where is the problem about the functioning of the ARO, not solving because it's not our topic. Thank you once again. Anna Maria, if you want to conclude it.
No, thank you also by me, and I would like to stress the importance also to answer our questionnaire also when we ask about which are the problems for the malfunctioning of the AROs, but also which can be the proposal of a reform, or if another question that we had is if in your system of law is necessary to adapt the statute of the Asset Recovery Office in consideration of the new, in order to implement the new directive, which reforms are necessary, and if, in your opinion, in the experience of your system of law, the reform of Asset Recovery Office are enough in order to better improve the role of this of the Asset Recovery Office, or if, for your experience, it would be better to introduce other kind of reform of this office, of this important body. So, because one of the aim of our project is also to give some all deadlines in the interpretation, but also some reform proposal for the future in the national and the international point of view. So thank you so much. Thank you so much also to the representative of Moldavia and Ukraine for their participation in our project. And Ernesto, Matteo, the next workshop about the asset management and the problem of the protection of the asset rights is in
on the 11th, on the 11th of July, which is a Thursday, and we will send you the posters and all the information about that. Three other things, if I may, very briefly, logistical, organizational. First of all, I specify again that we had the consent for this registration, this for the publication purposes on our website. Then please send me all the presentations you have shown. We will send you another reminder about that. But please do that with all the additional data you are able to collect, because everything is very, very useful for our final drafting of all the results of the project. And finally, we will send to the partners, mainly the feedback questionnaires for this workshop. Please fill them and send them back. We will let you know everything tomorrow, I believe. Thank you very much, and see you soon on the 11th.
Bye-bye.
Bye-bye. Thank you so much.
Bye-bye. Thank you. Bye-bye.
Thank you all.
Bye.
Thank you all. Bye-bye.
Thank you. See you.
Thank you so much.